Chan, my colleague. We are ready to begin. So it's 2 minutes after 9 a.m. Toronto time, 10 a.m. Uruguay time. So please feel free to proceed.
Okay. So let me check if it's recording. It is. Good morning, ladies and gentlemen. I would like to welcome you to the annual meeting of shareholders of Agriculture Investment Group Corp. My name is Jose Auski, and I am the Chief Executive Officer of the company. Pursuant to the company's Articles of Association, as the Chief Executive Officer of the company, I will preside as the chair of the meeting. We will now begin with the formal meeting to conduct the business set forth in the Notice of Annual Meeting of Shareholders. Also, in attendance at today's meeting is Juan Presa, the company's external counsel. At this time, I now call the meeting to order. Juan Presa will act as secretary of this meeting. We have appointed TSX Trust Company, the company's transfer agent, as scrutineer for the meeting. The notice calling this meeting of shareholders was mailed on March 5th, 2021, together with a copy of the information circular of the company dated February 23rd, 2021, hereinafter referred to as the circular, to all of the shareholders of the company of record on February 26th, 2021. The secretary will annex a copy of notice, the circular, the affidavit of mailing, and final tabulation to the minutes of the meeting. The scrutineer has submitted its report on attendance, and I would like to ask Mr. Oliver Kyung to please read the scrutineer's report.
Thanks, Mr. Chairman. There are a total of 82 management proxies received prior to the meeting, representing 83,147,905 shares. This represents a 74.33% of the issued and outstanding of the company.
Sorry, can you repeat the two figures, Oliver? The total and the percentage?
Sure. There were 82 management proxies received, which represents 82, which represents 83,147,905 shares.
Okay.
This represents 74.33% of the issued and outstanding.
Right. Sorry, one previous question. You said, Jose, that the meeting is recorded. Can we confirm that?
Yes.
Okay, perfect.
Hold on, let me confirm. Yes, it is.
Are you recording too, maybe?
Because this is not my session, so I cannot record it, but I do see the recording button is active right now on Zoom.
Okay.
Sorry.
Notice having been given in accordance with the Articles of Association and a quorum being present, I declare that this meeting is duly constituted for the transaction of business. With your consent, I propose to conduct the vote on all matters via verbal indications from shareholders present of either in favor or opposed. As the first item of business, I present the audited financial statements as at and for the financial year ended June 30, 2020. Copies of the financial statements are available for inspection at this meeting. The next item of business is the election of directors of the company.
Sorry, excuse me, Jose.
Yeah.
May we ask some questions?
Yes, absolutely.
Yeah, concerning the audited financial statements, actually there are two questions that I would like you to ask.
Okay.
The first one is about Casarone.
Yes.
I understand that Deloitte has not been able to access to the Casarone's audited financial statement for 2020, and that was the same actually the year before.
Yes.
So I wanted to understand what happened and why Deloitte was not able to access this audited accounts for that company.
Yes, the company is not allowed to have access, and we are really fighting with Casarone to get the access to this information, which is very important for the company. But Casarone is, it's not, I mean, they don't have they are not required to give us access to all the information we need. But we are really fighting to do it, and I can explain to you after this meeting all the things that we are doing. We are trying to do business with them in order for them to give us access to all the information that we need. And we are very, very aware that we need to have all the complete information as our auditors require to us. But believe me, Isabel, we are doing all the efforts to have access to that information.
Okay, and how reliable do you think are the information that you provide about the company's share in Casarone without that audited accounts from them?
Well, we have access to Casarone's financial reports, for sure, and on the other hand, we do an assessment of Casarone's most important assets, which are their farms. So we do every year, we assess the price of each farm that Casarone has, which are their more significant assets. So that's the information we obtain from them. Their financial statements, audited financial statements every year, and we assess their farms.
Okay. The other question I had was about the note 27.1 in contingencies part of the report from Deloitte.
Yeah.
We understand that there is a pending issue with tax authorities about tax exemption the company has applied since 2013, I think, until 2017.
Yes.
That could result in a cumulative contingent liability of a bit more than $10 million US.
Yes.
It is mentioned that the company is comfortable with this appreciation, but I would like to have your opinion about how cautious it would be to still have, a report, a recognized provision for this contingent liability.
Yes, that's a very good question. That's a matter that has like 7-8 years ago. We are discussing with Uruguay's tax institution, which is from the public sector, on how the tax should have been applied to the company back from seven or 8 years ago. We are arguing in a court of law with the tax authority from Uruguay. We are confident, but as it doesn't depend on us, the resolution, we did all our efforts, we are doing all our efforts to win this discussion on how the taxes should have been applied to the company several years ago. And I'm more than willing to send you all the reports that can describe how the issue started and how we are fighting with the tax authority from Uruguay to win this battle. I am more than willing. I have reports from all the biggest consultancy companies which support us on this legal matter. Just to mention KPMG, Deloitte, Pricewaterhouse. We are working with all of them to win this legal battle. And I'm more than willing to send you all the reports so you can have a great idea about how the situation started and where we are now.
And when do you expect this issue to be settled?
Well, now with all the with the COVID-19, all the public sector institution has slowed down their work. I don't have an answer for you right now when I expect to have this settled. But as soon as I have more information, I will send it to you. And you can call me anytime about this.
Last question on this one. Has the company stopped to apply those tax exemptions since
Yes.
2017? Yeah?
Yes, yes, yes,
Jose?
yes.
Yes, I would have an additional question on that point, because I understand that you are working with your tax advisor to win this fight with the tax authority.
We put, Jerome, not only our tax advisors, all tax experts from Uruguay, we hired them.
Okay, excellent, excellent. That's one thing. But from an accounting point of view, how do you manage to not make any provision and still be compliant with the IFRS requirement, which normally should entitle you to make any provision where you have identified a risk, and this is clearly a risk, even if you are confident that you can win. So, how do you explain this?
Yeah, I mean, we haven't made a provision yet because we don't see in the short term that there is going to be a resolution about this. But this is a good point, and I can discuss this with our auditors for the future financial report, whether if they think that it is important to put a provision on this. But for sure, I take note of this, and we can discuss this.
I think it would be wise.
The wording of the note 27, let me believe that the auditors who had been keen you to make a provision, and they said something that the management considered that it was not necessary. But at the end of the day, you have the final word. But it's very exceptional that the auditors make such a statement in the report.
Okay, I will talk to them, and we'll discuss about this with the auditor. No problem at all.
I have another question about the financial statements, if I may. I understand that today we are not voting and approving the financial statements, and also looking at the company memorandum and articles. I understand that the board of directors of the company doesn't have cannot approve themselves any financial statements. This is Resolution 94. And so I'm wondering how does it work in BVI law to who is approving financial statements? Is Deloitte stamp is enough, or what is the process of the approval of financial statements?
Well, the process is, Matthias, that the auditors take the company, they put a lot of people working with us, all the external auditors, they analyze every single transaction the company has made. We have meetings regularly for several months, and after they are okay with every single transaction, and they assess the value of our assets, they produce the report and they sign it, and that's how the process works. That is how the process works. They put a lot of people here for months, they do their work, and they prepare the report.
Okay, maybe this is a difference with French regulation or other regulation in the world, but as far as I'm concerned, and with my little experience of annual general meeting, every time the financial statements are approved in session by the shareholders. But maybe this is a difference of BVI regulation,
yes,
in which the shareholders do not need to approve the financial statements.
Okay.
But it's true that for me it's quite strange that the shareholders are not approving the financial statements during the annual general meeting. And I guess other people maybe feel like this, other shareholders around the world feel like this.
Matthias, sorry to interject. Sorry, Jerome, go ahead. But just on that point, you mentioned Article 94, which actually relates to the committees. And if you see what that article mentioned, is exactly that the committees may have the same powers as the board of directors, who are, in case, the ones that approve the financial statements. So as you well mentioned, in VBI law and according to the company's M&A, the one that actually has to approve this sort of document is actually the board and not the shareholders. It's different. I understand that it's different in French law, but it's not, again, it's not applicable here, what you're saying.
Okay. So I understand that...
When the board will be asked to approve the financial statements?
I'm sorry?
When the board will be asked to approve the financial statements?
I'm pretty sure the resolution already passed. I can send it to you right after the meeting if you want.
Okay.
But any question, Matthias, that you have on the financial report, we'll put our energy to answer everything about the financial statements. No problem at all.
Okay, thank you very much.
Yeah. Okay, so I'll continue. The next item of business is the election of directors of the company. As set out in the circular, management is nominating a slate of 3 candidates for election to the board of directors of the company, namely Laurent Mador, Matilde Tomagnini, and Simon Bumbaca. It is...
Sorry.
Yes.
I was muted, and I didn't realize. I wanted just to take the opportunity before we leave the financial statement.
Okay.
But I think it's a very good opportunity, Jose, to congratulate how the financing, the global financing situation seems to appear.
Thank you, Carlos.
Decreasing the debt at this point, I think it's a very original and good news for this company since I started getting close, and I just wanted to point it out. I think the General Assembly is an opportunity also to say this kind of things.
Thank you very much, Carlos, and you know how I really appreciate that. I really appreciate it. Okay. Sorry?
No, I say I fully agree with Carlos'
Thank
comments. You did, Jose, a very good job with
Thank you, Jerome.
and everything. And
Thank you.
we already had shared that together, but I reiterate it publicly to congratulate you for your work.
Thank you very, very much, and I really appreciate it.
We agree as well.
Thank you, thank you. It is stated that there are no further nominations. The election of the directors of the company is an ordinary resolution and must be passed by a majority of the votes cast at the meeting. I will now pass the resolution to elect the proposed slate of directors. Those in favor? Opposed?
Yeah. What do you want me to do? Raise my hand or?
No, the vote is already cast. That you don't have to actually.
Yeah, we voted already.
Could we have the results then?
Okay. I declare the motion passed and that Laurent Mador, Matilde Tomagnini, and Simon Bumbaca have been elected as directors of the company.
Could you give us the percentage?
Sorry?
Could we know how many votes did they get?
I guess that TSX...
Oliver, do you have that number?
Yeah, I can certainly read that out now if there's a preference for that. So for the election of Laurent Mador as director, we received 53.97% of votes in favor, 46.03% abstaining, or withholding, I should say. For the election of Matilde Tomagnini, we received 53.97% of votes in favor, 46.03% of votes withholding. And lastly, for the election of Simon Bumbaca as director, we received 73.95% in favor, 26.06% withheld.
Okay.
73 point?
95%.
I have a comment on this, Oliver. Did you take into account the comment that I sent you by a letter yesterday?
Sorry, what was the comment that you were referring to?
It is a Jerome Croce from Alex AM, and I addressed you a letter from Bennett and Jones yesterday. Are you aware of it?
Yes, that's right. So we have received that letter from Bennett Jones, and what we did was, because as transfer agent, we were not made aware of any votes that were to be excluded or considered to be that should not have been counted. So we have directed this over to AIGC, and they are aware of it. And we've also responded this morning back to Bennett Jones in confirming receipt of the letter as well.
Okay.
Can
Jose, you received the same letter as well? Are you aware of it?
Sorry?
You received a letter?
Yes. And I replied the email as well.
Can you share your reply with us?
Yes, that we will analyze the letters. He sent 2 letters.
Can we share the content of the letter?
I do apologize, but that is actually not something that is to be discussed in this meeting.
Yes, it is one. I'm sorry, because basically Grow Production, which is 50 million shares, and Chameli, which is the same amount, about 40 million shares, representing about 30% of the vote, have been struck off. So this company do not exist anymore, and by right, Article 50 of the company, of the AAG article of association, they are not authorized to vote and to exercise any legal right. So this is exactly what we have to discuss. These votes are illegal, referring to the Article 50 of your memorandum article of association. Please check.
Not only it's not TSX the right authority to determine that, but it's also not the company in line who has to determine that sort of thing. Velice law or even VVI law would have to be approached in the manner that said law is actually established.
No,
we're not here. We're not.
Juan, you are a lawyer. Could you please read for us the Article 50 of your bylaws?
Yeah. Any person other than an individual shall be regarded as one shareholder and subject to the provisions of the following regulation. The right of any individual to speak for or represent such shareholder shall be determined by the law of jurisdiction where and by the documents by which the person is constituted or derives its existence. Okay. Again, the second part, I think it's very clear in which says the board may in good faith seek legal advice from any qualified person, and unless and until a court of competent jurisdiction shall otherwise rule, the board may rely and act upon such advice without incurring any liability to any shareholder. And I think that second part is pretty clear in terms of how this should be proceeded. Again, Jose has asserted your claim, has received the letter sent. TSX has as well. So I think the competent jurisdiction in any case and the legal advice we would seek is the right path to go with these assertions.
But wait, did I understand well? The two companies you mentioned are not alive, to call it this way. It's not very technical. They don't exist. Is that what you're?
It's not. It's in those sort of jurisdictions. There's a big difference between when a company is struck off and when a company is diluted or liquidated. So there are 2 different concepts that, again, we would need to seek the correct legal advice, given that I'm not a lawyer in VVI or nor Velice, in order to assess this situation.
I understand, but Juan, hello, Juan, Carlos speaking. If after consultations we came to the conclusion that the 2 mentioned companies are struck, if that is the word, are no longer existing, then that conclusion should be brought back to today, because if today they are not existing, then even if the consultation takes place in 5 days or in a month.
Again, just one sorry to interject. Being struck off and being dissolved are two very different concepts in these jurisdictions. Again, I'm not the right person to discuss what are exactly the differences.
No,
but it's a matter of.
I'm not discussing the difference between struck and dissolved. I'm saying that what you consider that should be done is that we check in the appropriate jurisdictions whether if they are struck, dissolved, or perfectly live. If whatever the conclusion is, what needs to be pointed out is that that is a conclusion of April 14, which means that if they are struck today or dissolved, if everything is okay, nothing changes. But if they were struck or dissolved, we need to make sure that they are not struck or dissolved the day that the consultation.
No, it's not that. It's the matter of analyzing as well if the activity of these companies that you claim that are struck off are actually valid or not, and are actually those shares can be voted or not. Again, it's the subject. It's much broader than just simplifying it as a struck off or not discussion.
No, I'm not
Again, I think
You're on mute. Jerome, you're on mute.
Jerome, you're on mute, Jerome.
You're on mute, Jerome.
Just to
Jerome,
mention,
you're on mute.
okay, you have been provided one with a notarized copy of the strucker from the Register of Belize and BVI. And let me, for your information, read you the Schedule B, Chapter 270 of the Belize International Business Company Act, let's say point A, where the name of a company has been struck off, the company may not legally, blah, 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 carry on any business on any way which deal with the asset of the company, and C, act in any way with respect to the affair of the company. So the striking off of the name forbid the company to vote. That's very simple. That's for Belize.
Okay.
I can provide you the Schedule D.
I think none of us here are Belize lawyers.
Let me finish. Schedule D, BVI, Business Company Act 2004, Article 215, where a company has been struck off of the register, the company may not commence carry on business of any way, deal with the asset of the company, and C, act in any way with respect to the affair of the company. Exactly the same. So these two companies must not, cannot participate to this vote. So meaning that the election of Laurent and Mathilde have certainly less than 25%, and for Mr. Vubunka, 74 minus 30, it makes 44. So none of them should be elected.
Again, none of us here are lawyers in Belize nor in BVI, and that those assertions.
I made my homework and I did that, and I give you the summary and the information.
Okay,
what you are going to do
you have to
today?
consider what you are only reading one article, and let me explain, okay? Because just reading one article doesn't necessarily make for the whole legislation to be summarized in one thing, okay? So here's the thing.
I have legal opinion from both jurisdictions.
Okay, so here's the thing. If a company may not act, is it a liability for them? Does those acts had any effect on third parties? So it's not a matter of just simplifying it as one article. Again, we will require the necessary opinions and the necessary advice from competent jurisdictions, okay, in order to resolve this matter.
So what I suggest, if this is effectively what you need to do, what you want to do, I suggest that you put the election of the 3 directors on hold until you got your legal opinion, which confirm your view, which I got very seriously.
We cannot go in detriment of what was voted. Again, if there's anything that invalidates those votes, we can always go back. But the assembly, again, is today. The matters to be discussed at the assembly are actually pretty listed as they were in the circular and the notice. So I think, and again, according to the company's bylaws regarding the General Assembly, the points that need to be addressed here are the ones that are on the notice and in the circular. Nothing else should be addressed. So it's a matter of discussing those points after the assembly.
tard. D'accord? Merci.
Just to well understand what we are saying. So, Juan, you're gonna see in how we should deal with this issue in the following days, and if the answer is that the votes should be cancelled, then what the minutes will be adjusted, and the votes will be of these two companies will be cancelled. That's how we will work. Just to understand it clearly.
Basically, the points to go forward is seeking the correct legal advice in order for them in the competent jurisdiction to analyze how the process is and how does this affect voting, if in any way. That's exactly what is going to happen.
Okay, and so you will release the minutes after of this meeting. You will release the minutes after you have your legal advice, if I understand.
No, the minutes of the company, I mean, the minutes of this meeting shall be transcribed. It's just, and the report has already been established. If there's anything that invalidates those votes, that can always an act that can be subsidized in the future. Exactly.
So, well, are you going to reconvene another annual meeting of shareholder? What's going to happen concretely if those votes are considered invalid?
Depending on the advice that we get from the.
Let's consider they confirm it's invalid. Then what happens?
I cannot say if it's. I cannot act on a contingency. I'm sorry. It's the result from that advice would be what basically would establish how the action will be going forward. So it's a matter of seeking the correct legal advice in order to have this.
And how are you going to inform us on the results of this legal consultancy?
When we have it, we can share with you the contents of this information, obviously, from the competent lawyers in the jurisdiction.
I'm sorry, I'm just a little outside of the topic. I was not aware of it, but I'm just a little surprised that we can still confirm a vote when there is a question mark on some of the shareholders were allowed or not to vote. So I think the proposal, just to finish my sentence, sorry, the proposal to postpone this election to maybe in a week or so when you have the results would be very reasonable.
Well, the thing is that the votes have already been cast, and it's not an obligation. I mean, given that the assembly is today, and that the votes had already been cast for the shareholders that have already given their votes, these results would be the ones that arise from this general assembly. If again anything needs to be subsidized in the future for any reason that would invalidate any vote, that's something that we need to address whenever that comes. But as of now, the results are this. Okay.
Another question about this, if I may. May I know who in the management of AEG proposed this to nominate these three directors?
Go ahead.
Yes. No, I'm asking who in the management of AIG has proposed to nominate these three directors?
The shareholders themselves were the ones. I think Jose maybe can answer that better, but the shareholders are entitled to, any shareholder is entitled to propose any director to the meeting. That's in the company's bylaws, Article 39C.
So could we know which shareholder proposed which director? Because Laurent and Mathilde served as significant shareholder, representing a shareholder so far. So I would love to know who are they. And I just remind you that the Article 70 of the bylaws require that the board should be aware of the significant shareholder final beneficiaries. And there is a legal opinion which has been published 1 year ago by Joaquim Pons de Lima, which was the legal advisor of AIG, that says exactly that thing. The board should be aware of the final beneficiary of the significant shareholders. As far as I'm concerned, everything has been disclosed, which is not the case for neither Laurent or Mathilde. And now you appoint Simon Vumbaka, and you are in breach with your Article 39B2, which requires you to provide information about the shareholder to the shareholders before the vote. but it appears that Mr. Vumbaka is a personal lawyer of Mr. Sartori, and we were defending him in the litigation that we had 6 months ago about his settlement. So I think this information is key and should have been highlighted to the shareholders before the vote. Why didn't you do that?
Going back to the circular contains a brief bio for each shareholder. The reason behind nominating these shareholders is because if these directors, I apologize, if it's their proposal to, even if they were designated before, to go through a general assembly, they are on their full right to do so in order to be voted at the meeting rather than being designated. That's the first thing. Regarding your second point,
it was the right, but we have the right with regard to the Article 32B2, 39B2, which is you, AIG, must provide information and transparency to the shareholders before the vote. You have to disclose who this guy are going to represent, and
it's especially,
are they related person to any other shareholders or any big interest? And the fact
that is not actually required.
The value of Mr. Sartori definitely should have been disclosed.
That is not actually required. The bylaws are very specific in that you have to share a brief bio of the case, which was included in the circular that was sent again to all shareholders via our scrutiny agent. These topics, whatever should have been included is not necessarily what is necessary to be included. I mean,
yes, when we are talking about conflict of interest, it must be disclosed. And Mr. Vumbaka is definitely in conflict of interest, being the personal lawyer of Mr. Sartori. Mr. Sartori having been in litigation with the company. How could Mr. Vumbaka defend the best interest of the company now?
Okay. Again, this is something that it's not a matter of this AGM, and we can discuss this in detail, again, in your letter that you sent to Jose after the AGM, but this is not relevant to the votes that are being cast here. Whatever claims you have against any of the directors that were being nominated or beneficial owners, it's something that cannot be resolved or has anything pertaining to the votes cast at the meeting. So again, this is something I know you've been, you sent those claims to Jose regarding, for example, the struck off and other things, but this is something that are totally out of the ordinary course of business that is being handled at this meeting.
Wait, let me understand.
The question will be reported in the minute.
Excuse me?
Could you confirm as secretary that my question and comments will be reported in the minutes?
This is being recorded, yes.
And there is something I don't understand. I have some experience in general assemblies. If the shareholders cannot discuss about the candidates that are being proposed as directors, in which context can this be discussed? I mean, what do you mean? You say we cannot talk about who can be candidates for director at the time of voting independently, whether the votes are doing electronically previously or not. It's the same. I can change my vote. I can be convinced that Simon Vumbaka could go for the best interest of the company. I can tell you that I voted negative, but I could now change and vote positive because things are being said at this forum, which is exactly the one that corresponds to a general assembly of shareholders. It's the only annual opportunity to do so.
I understand that, but neither Jose, myself, Oliver, TSX for sure, or any of you are making the case here to any of the directors. Again, the assembly is just to recount the votes that were casted, and we are not making the case for any of them or if they should have been elected or not.
Okay, I'm not saying what needs to be said or what I consider that you cannot avoid being said is talking about I'm not saying whether it's good or bad that it was elected. I disagree that this is only a counting vote session. I disagreed from the very beginning. This is a general assembly. And in the general assembly, the shareholders manifest whatever they want to manifest corresponding to the points that have been proposed for the assembly. And in this particular case, this is one of those points.
Okay, just going through the bylaws of the company, Article 39B1 actually says that no business may be transacted that is not in the notice or properly brought before the meeting. So it's a matter of discussing exactly what was previously said.
Are you saying that the election of directors is not in the point of the meeting?
No, of course it is.
So then we're talking about the election of directors. That's it. Okay. What are you talking? Are you telling us that we cannot speak?
No.
About the points that are in the circular communication?
Of course.
Okay. Let's. I think what needed to what you said, Jerome, is for me enough concerning the candidates.
Okay. I have another point. I understand that Mr. Mador and Ms. Tomanini are already director of the company as representing a significant shareholder. And maybe we can take the opportunity that Mr. Mador has joined us in the meeting to maybe ask him which significant shareholder he was representing, because I don't have this in mind.
You're muted, Mr. Mador.
Okay.
Mr. Mador?
Okay, so maybe if it's not here, someone else, someone who knows, maybe. It's just a simple question. I don't want no tricky question, just to understand, because
I'm representing Grow, which has been struck off.
Mr. Mador?
Grow.
Mr. Mador?
Mr. Mador is Grow.
And
no, I say he might. And Grow being struck off, it becomes silent, which is logic.
Sorry. My FedEx arrived. So I represent Adventex.
hold on, Laurent. There is another person, Clement Bonnet, at the meeting.
Yeah, Clement is working with me with Unibel.
Okay.
And if someone knows for Ms. Tomanini, she's not here, but maybe you, Jose, or Juan, or Mr. Mador, or anyone else knows which shareholder she's representing.
I remember that last year she was introduced by Chameli.
Yeah.
I'm not sure that when she has been appointed after the resignation of the two previous directors, she has been appointed still by Chameli.
Chameli.
I'm not sure.
I think, Matthias, that can be verified. That I don't have the answer for you right now, but given that they are directors representing significant shareholders, that's an answer that we can provide, no problem.
Which would be very interesting, because if Mathilde is effectively representing Chameli, and Chameli having been struck off in November 20, all the decisions she signed still since November 20 are void and null. Please quote my wording in the minutes.
This is being recorded, Jerome.
Yeah.
Okay, thank you, Jose.
Yeah. So I will continue. The next item of business is the appointment of the auditors of the company for the ensuing year and to authorize the directors of the company to fix the remuneration of such auditors. This ordinary resolution must be passed by a majority of the votes cast at the meeting. I will now put the motion to the meeting with respect to the appointment of Deloitte as auditors of the company to hold office until the next annual meeting of the shareholders, and the authorization of the board of directors of the company to fix the remuneration of the auditors so appointed. Those in favor? Opposed? I declare the motion carried and that Deloitte have been duly appointed auditors of the company to hold office until the close of the next annual meeting of shareholders, and that the directors have been authorized to fix the remuneration of the auditors.
Would Olivier and Tony give us the figures, please?
Yes, it's $80,000, but I will fight for a reduction.
No, I was talking about the figures of the votes, the results for.
Sorry.
I recognize you.
Yeah.
Cutting the charges, that's good.
Yeah.
So, Mr. Chairman, I can report the vote results on that.
Yeah.
On the appointment of auditors, we received 99.88% of votes in favor. We have received 0.12% of the votes withholding on the resolution.
Oliver, one question, which I don't know if it corresponds or not, but this is the percentage of the votes casted. But do we know how many, what is the percentage in the total capital of the company? I don't know if my question, I'm not sure I'm making it clear.
Yeah, sure. So, a total of 74.33% of the capital of the company, of the issued and outstanding shares, were voted. And of those votes that were received, 99.88% of votes were in favor of the appointment of auditors.
Yeah, you mentioned it at the beginning, the 83 million votes. Sorry, it's clear.
Yep, no problem.
Okay. The next item of business is the approval of a share repurchase program. The ordinary resolution must be passed by a majority of the votes cast at the meeting. I will now put a motion to the meeting for the approval of a share repurchase program. Those in favor? Opposed? I declare the...
I would like to, Jose,
Yes, go ahead.
a comment before we get to the vote, or we read the already existing votes.
Okay.
Because first of all, there is a generic comment about all the points. Most of them are not easy to understand. I would propose, if that is possible, and if everybody agrees, that in the future, the points should have some kind of explanation, because in fact, I dedicated my last 2 weeks to try to guess what was behind each of the points, what did it mean exactly, what are we referring to. In this case, it's a little bit easier than in other cases that we will see in the next points, but to approve a share repurchase program, what does it mean? Why? What for? We just sold treasury shares. Do we think we made a mistake and then we want to buy now? Or I congratulated you how the financing picture became much better in the past 2 years. But is it so good that we can say, okay, let's go out and buy new shares, buy back the shares? Can you foresee, with your financial profile, a clear liquidity that would advise to revise shares in the next 12 months before the next annual meeting?
Sorry, Carlos, I take note of your comment. I totally take note of your comments, and I'm also telling you that another person joined the meeting. It's Steven Nguyen, which I think is from TSX. Am I right?
That is correct. Steven Nguyen, TSX Trust Company. Thank you.
Okay. Okay. So,
Comment and a question. Question about liquidity.
yes, that's a very good question, Carlos. You know how the liquidity situation of the company is. It is clear that the resolution talks about creating a program, but it does not refer on how the program should work. So, based on the results, which I haven't read yet, if you let me finish, I will talk to you, Carlos. I will.
I didn't say anything.
Okay, here it says, I declare the motion carried and that the creation of a share repurchase has been approved. Okay? Can you hear me?
I'm
So-
not what you're talking about. I'm a bit lost.
So, the item didn't refer on how the program should work. So we clearly need to figure a program to set this share repurchase process, which has to be based on our cash constraint, which is very significant for the company. So we need to clearly analyze on a process to apply this share repurchase program. So,
If I can just rebound on what Carlos said, that's the tricky thing. I mean, you
Okay.
ask us to vote on some resolutions without knowing what you want to do with them. You ask us to vote for a share purchase program without knowing what you want to do with it, or if the company can afford it, and that's the same thing for the other resolutions coming soon. So that's really the weird thing. I mean, how do you expect shareholders to vote properly? They don't know the context and what the company is going to do with the resolutions that they voted.
I take note. I totally take note of your comment, Isabel, and believe me, I as part of the management, I'm the most concerned person for this program, because we need to figure a solution working under a very tough cash constraint. So it's going to be a challenge, and how this program will be implemented will be a very delicate thing for us to manage, given the cash constraint we have. So
how this repurchase program can be in the best interest of the company, unless you said that the company will buy shares, its own shares, expecting that the shares value will go up and then be able to make a sale of treasury shares in the future with a better price. But this is quite speculative, looking at the last years and how the shares went down. So I don't really understand the interest of the company in this repurchase program.
I disagree with you on the speculation thing, Matthias, because the price is clearly settled on the circular, which is the price of the last rights offering. It is $0.5 per share. So in that sense, the purchasing price is clear. The conditioning of the application of the program to our cash possibilities, it is very clear. And believe me, that we have received several requests from shareholders in the past who were or are or were not happy with the company, for us to provide them a solution so they can exit the company. Given that it is not a public company, it is a private company, the only way for some shareholders or for every shareholders to sell their shares is to find a purchaser for their shares. So this would, the idea behind this is to provide a solution in case it is possible for those shareholders who want to exit the company. That is the objective. Another thing is how this program should work, and I take fully note of what Isabel and what Carlos are saying. But the objective is it's clear for me.
Jose.
Yes, Jerome.
Sorry to ask you, when we started to discuss this point 4, the share repurchase program,
yes,
you look to be a little bit in a difficult position, not really keen to disclose everything. So, who is the management in the company?
Oh, come on, Jerome. You're not a psychologist. That's not serious. Honestly, that's not serious. I'm not having fun here. Okay. I'm not laughing at all about this. So please don't be a psychologist to me.
Okay. When it is written, the management recommends to vote for. Who is the management? Is that you?
Absolutely. I'm the one, Jerome, let me tell you. I'm the one who received hundreds of phone calls from shareholders, and let me tell you, they are not happy. They are not happy. They were happier compared to how they were 2, 3 years, 4 years ago.
Send them to me, Jose. Send them to me.
Yeah, I mean. Okay. But believe me that I know what I'm talking about. Believe me.
Okay. Thank you, Jose.
Absolutely.
Could we have the details of the votes, please, Oliver? For, against?
Sorry, I was muted for a second here. Bear with me. On the approval of the share purchase program, Mr. Chairman, we have received 74.58% of votes in favor, 25.42% of votes against.
Okay. The next item of business is the amendment of the Memorandum and Articles of Association of the company according to the proposal presented to shareholders. This ordinary resolution must be passed by a majority of the votes cast at the meeting. I will now put a motion to the meeting for the approval of the amendment of the Memorandum and Articles of Association of the company according to the proposal presented to shareholders. Those in favor? Opposed? Yes, Carlos.
Before we vote, I would like to make some comments.
Yes.
Same as my observation about how difficult it is to understand the things that are being proposed to be voted. I think that one of something that we could clearly identify here in this company is that we have communication problems. Communication problems, for example, means that I personally, Carlos Abud, as shareholder, never received the official document to participate in this meeting. Never. I didn't receive it. And I just, thank God, I took notice because of conversations, and then thank you, Oliver, you very quickly solved the problem and you, Jose, with the electronic document. Now, if that is the case, because there is something also behind all the points, which is very difficult to guess. What is the interest of the company? What is the interest of the company to reduce from 21 to 10 days when in fact we should put the 21 days, we should get it to 65 days. If 21 days is not enough, why do we want to do it in 10 days? If there is no way to secure